I'm going to give you some really good information I think that will help you. These have been in effect for a while in federally, and in the various states, they may have come into effect in different times. So I'm going to get more into that in just a minute. And we're going to be also covering the best practices for revising your workers' comp policies to meet these new OSHA regulations, because there are going to be some changes that you're going to want to make in your handbook. We're also going to be talking about the top potential state law changes. Now, of course, there are attendees on this webinar from many states throughout the country. I practice in Oregon and Washington primarily. I did do kind of a survey of some of the changes in other states too, but mostly I'm going to talk about the trends that are happening in state employment laws. And then also we're going to talk about the top federal changes that you may see with a new administration. So we're going from an administration that was more liberal and to an administration that's going to be much more conservative, and how is that going to change the employment laws in the coming years? So that's what I hope to cover with you today. Okay, so first we're going to talk about OSHA's new reporting rules. So what this is OSHA basically put through a regulation. It was one of those regulations that was contested. As you know, the wage and hour regulation was contested, and a lawsuit was filed against it in Texas. Texas tends to be the state where these injunction lawsuits are filed against federal regulations, because it is a more conservative state. More likely to give you, to rule on those injunctions. So basically what happened is OSHA issued a final rule. The final rule became effective on January 1st, 2017. So it's already been in effect a while. The final rule was the title of it was Tracking Workplace Injuries and Illnesses. And it's really involves reporting electronically your 300 log electronically instead of through paper. And so just looking at the title of the reg, you wouldn't necessarily think that it contains some very, very kind of contentious new retaliation issues. So basically there are four really kind of hidden retaliation claims that are in this new federal rules. The first one requires, the rule in itself requires employers to electronically submit injury and illness data to record on-site OSHA injury and illness forms. So that in of itself seems pretty innocent. But it clarifies also that an employer's procedure for employer reporting of work-related claims has to be reasonable, and it can't deter employees from reporting work-related claims, and that seems reasonable. It requires that employers inform employees of their right to report work-related claims free from retaliation. This part right here really requires that you do much more in writing in your employee manual or however else you do it to give employees information about how to file a workers' comp claim. And that it also prohibits retaliation for reporting workers' comp claims and allows enforcement of the retaliation provision through the citation process. So OSHA can now come out and either do just a general inspection, or if they come out because there's an injury that they're looking at, then they can go ahead and issue a citation for retaliation. So, you know, that's kind of where this comes into play. So the first thing that this did that was kind of hidden in the rule was it questioned blanket post-accident drug tests. So what the new rule does is it indicates that unless you're required by state or federal law, for example, the Federal Motor Carrier Safety Act or the DOT rules, unless you're required by law to do post-accident drug testing, a blanket post-accident drug test may inappropriately deter an employee's reporting of an accident. So what they're saying is that if you have an employee that gets injured and you're going to automatically drug test them, automatically, it's just they get injured and you're going to send them for drug testing, then if they think they might not pass that drug test, they may not report their workers' comp injury. And they feel that that sort of chills or affects the employee's rights or desires to report the injury, and that's a bad thing. So they want to prevent employees from feeling like they can't report their injuries because they're going to show up with alcohol or marijuana involved in, or some other drug. So they've made some changes as to how you can do post-accident drug tests. And the first thing is you can't have a blanket policy. You can't just have a policy that says if you get injured, you're going to have to get drug testing unless you have a state or federal law that requires you to do that. And so what if you do have such a policy in your handbook, they're saying that is going to support or be evidence to support retaliation under the rule. And you could be cited for that. And that's especially where it's really obvious that the injury wasn't caused by drug use. And they give a lot of examples in the rule or in the Federal Register about what they mean by that. So for instance, if you're sitting at your desk and a ceiling tile falls on your head and you're injured because of that, your injury wasn't caused by the ingestion of drugs or alcohol, and therefore sending that person who's injured by no fault of their own, nothing that they did, a ceiling tile falling on their head, or they get stung by a bee or something like that, then sending them off for drug testing isn't legitimate and isn't reasonable because drugs or alcohol did not contribute to that injury. So that's their main problem with blanket post-accident drug and alcohol tests. Okay, so what should you do about this? We have clients doing a lot of different things. Some of our clients are just saying, we don't care. We're going to go ahead and have a post-accident drug and alcohol test in our policy, our drug and alcohol policy, and we're not going to worry about what OSHA is going to do. So that's certainly one choice. The other choice is, and one I think that is reasonable, is to review your drug testing policy. You can review it on your own or with your attorney, and really ask, are you legally required to drug test after an accident by state or federal law? If you are, then keep the post-accident drug testing policy as it is, because it's a legal requirement that you're required to do because you're maybe a federal contractor or because you have to comply with DOT rules, or there's some other state rule that requires you to do it. If not, then perhaps a blanket drug testing policy isn't reasonable and you should review it. So if you're reviewing your drug testing policy, you're still allowed to have a drug testing policy. It just can't be a blanket one. What you want to do is make sure that the policy includes a reasonable suspicion standard. So you want to have some language in there that says you're going to look at the circumstances surrounding the injury, and you're only going to send somebody off if it looks like drugs or alcohol contributed. And so you're going to want to jot down at the time, take notes, or have your supervisor take notes on what led you to that belief. Was the person slurring their words? Did the accident happen in a way that it shouldn't have happened? Like this is a person that drives a forklift all the time, and this time they drove a forklift into a pole right in the middle of the warehouse, and they maneuver that pole all the time. So, why did they hit the pole this time? That happened in a way it shouldn't have happened. So, you can use that to supply reasonable suspicion. Or you can go to the reasonable suspicion part of your drug and alcohol policy. Many of them have a reasonable suspicion definition, and use one of the parts of that definition, slurring speech, slurring words, their eyes are bloodshot, they're just acting like they're drunk, whatever, and document that. And then you're going to want to review the circumstances of the accident immediately. So because sending somebody off for drug testing days after the accident isn't going to solve anything, and it probably is going to engender a lawsuit for you. Not only a complaint. In fact, I had to defend such a lawsuit for one of my clients one time when they sent somebody off for a post-injury drug and alcohol test 3 days after the event occurred. So you want to, if you're going to do it, you want to do it right away. And then have more than one person observe the employees, so there can be an agreement about whether there is reasonable suspicion to send them off. Oops. Sorry. Okay. And so I have some language here. Oh, the other thing that isn't in there, and I apologize for not putting this bullet point in, but the other thing OSHA wants you to do is you can't just send the person who was injured off for post-accident drug testing if you think drugs or alcohol played a part in the accident. You need to send all of the people involved in the incident. So, for example, if you have a driver and their passenger in a truck and they get into an accident, and probably 9 times out of 10, most people would just send the driver off because the driver is the one that's controlling the car. However, OSHA would expect that you would send both the driver and the passenger. If you have people injured on a line, a manufacturing line, and there was something that occurred on that line that caused the injury, then you would send all of the people in the area who were related or somewhat in the same sphere of control off for drug and alcohol testing. Similarly, if you have a forklift driver and you have somebody basically showing them how to, or someone telling them where to go on the forklift, you're going to want both the person that's directing the traffic and the driver to go ahead and go off for drug and alcohol testing. Somebody's phone needs to be muted out there. I don't know if other people are hearing that background noise, but I am, and I think it's because somebody's phone isn't on mute, so just kind of give you that information. So I have some language here that is language you could use for your post-accident drug testing that would comply with OSHA's new requirement. And that is any employee involved in an on-the-job accident or injury under circumstances that suggest the use or influence of drugs or alcohol in the accident or injury event may be asked to submit to a drug and or alcohol test, period. And then in quotes, involved in the involved in an on-the-job accident or injury means not only the one who was or could have been injured, but also any employee who potentially contributed to the accident or injury event. And as you see, that contains the two areas that they're concerned about, that you have reasonable suspicion and that you're testing everybody. You're not just concentrating on the one that was injured because they feel that's discriminatory against the employee that was injured. Okay, so moving on. There's interplay between the workers' compensation statute that indicates that a work-related event is not. So this is one of the things that you might look at that would give you the ability to test for post-accident drug, a state law that would give you the ability to have a blanket drug and alcohol testing policy. And for instance, in the state of Oregon, there and most states, I believe, there is a statute that says that if the major contributing cause of the accident or injury was the consumption of drugs or alcohol, then then the injury event, the workers' comp injury, may not be compensable. I actually talked to our OSHA person here, and he didn't really believe that statute in and of itself would be of the nature that would allow you to have a blanket post-accident test, but it's certainly something that you could fall back on. I still think that it's relevant and related. Because, how do you get evidence that the consumption of drugs or alcohol was involved, but to send the person off for post-accident drug testing? So keep in mind that the OSHA, this final rule wasn't legislatively drafted. It was just done in rulemaking. So there are defenses against it potentially, and especially if the Trump administration wants to undo the rule, as they would like to undo many rules, that may end up happening. But for now, it's in effect, and it hasn't been enjoined, and you would need to comply with it. In some states, we've talked, I think, about that there is an argument that your state workers' comp law allows for the use of evidence of consumption of controlled substance. Okay, so that's one area. The blanket drug testing policies is one area that this new OSHA requirement that you record accidents online has sort of hidden within the rule. There are two more. The second one deals with safety incentive programs. And so many employers have programs that say that if you're injury-free for a year, then you'll get a bonus at the end of the year. So that would be a safety incentive program that would be related to whether the employee suffered a workers' compensation injury, or if the whole group might get a bonus if nobody in the group is injured, or if there are only a few number of injuries. That's exactly the type of safety incentive program that OSHA says is not permissible any longer. You cannot have a program that denies a benefit, a bonus, or other reward based on whether somebody has a workplace accident. And so the rule, the language in the OSHA rule provides, it's a violation of the final rule for an employer to take adverse action against an employee for reporting a work-related injury or illness, whether or not such adverse action was a part of an incentive program. Okay, so the question is, then, can you have safety incentive programs? Or are they dead in the water? Are they not permissible at all? You can still have safety incentive programs that give a reward as long as it's not based on having an injury. So if it's based on, for example, following the safety rules, then you can still have that. If it's based on things as identifying hazards or suggesting changes to make the workplace safer or attending safety committee meetings. Those are all permissible things that you could have a safety incentive program associated with. Okay, so injury reporting. The new OSHA final rule also takes a shot at employer policies that employees have to immediately report a work-related injury. And this is one that I think I have personally a real problem with, because first of all, you have requirements as employers to be able to provide Form 801s or the workers' comp forms to employees to be able to have them report their injuries. And unless they tell you they were injured, how do you do that? Secondly, you have obligations to your insurer to let them know that there was an injury so that they can begin the process and process time loss, in a timely manner, et cetera, et cetera. And you may, in fact, in my state anyway, there are penalties for failing to do that in a timely manner. So, and in addition, if somebody was injured at the workplace, you're going to want to know, what happened? Why were you injured? Is there a safety issue that we need to fix? And if people don't report it immediately, somebody else could get hurt. Whereas, if they had reported it right away, you could have prevented another injury. So there are all sorts of really good reasons to have a policy that says an employee needs to immediately report an injury. And in addition, and you might want to check, I didn't check every state's law. I do know in Oregon and in Washington, there are provisions in our statutes that actually say injuries must be reported immediately. And so it seems to me that that would give you the right to have a policy that says injuries must be reported immediately, just as with the blanket drug testing policy, if there's a statute that requires you to have it, then you can have it. The same with immediate reporting of injuries. So check your state law, your own state law, and see if you have a provision. It will be in the section of the workers' comp statute that deals with reporting of accidents or injuries, and see whether it says anything about having to immediately report it. So, and I'm just giving you an example. This is the Oregon state law that I just spoke about. It said employers shall immediately and not later than 5 days after notice of knowledge of any claims or accident report it to their insurer. And then similarly, another statute in our statute says notice of an accident resulting in an injury or death shall be given immediately by the worker, but not later than 90 days after the accident. So I'm using that statute for my clients as a reason. I am still revising the workers' comp policies because you have to, but I'm using that statute in my revisions to the workers' comp policies to support that if somebody has an accidental injury, they need to immediately report it. Now, an accidental injury is different from an occupational disease. And occupational diseases, and I've given you the Oregon statute, and I would surmise that most states have, because workers' comp law is very similar state to state, will have a very similar statute to this. So occupational disease claims are different from accidental injuries. They are things that occur over time from repetitive trauma. And so when you have an occupational disease, an employee may not necessarily know that work has caused that occupational disease. Maybe it's a back issue or carpal tunnel syndrome or some other repetitive trauma event until they go to the doctor and the doctor says, oh no, this was caused by your years of reaching or your years of bending or whatever. So you really do have to separate out accidental injuries and occupational diseases for your employees and explain the difference between them in order to have a rule regarding immediate reporting. So, and I will go through how I do my work, how I'm doing workers' comp policies to address all of these issues that OSHA kind of has thrown in our way. This goes to what I was just telling you, that there's a difference between accidental diseases or injuries and occupational diseases. And to my thinking anyway, I think OSHA seems to have blurred the two of them and with this immediate reporting requirement, because it doesn't make sense that you don't report accidents immediately, whereas it does make sense in an occupational disease context where you may not report that immediately. Okay, so as I said, it's reasonable for policies to give explanation about the difference between the two types of claims so that employees aren't confused on when they have to let you know that they've got a workers' comp claim. So best practice to implement these OSHA rules, as I've said, is to revise your policy, your workers' comp policy, and your drug and alcohol policy. The workers' comp policy should do the following things: clearly explain the process for filing a workers' comp claim. Define the types of claims. So define an accidental injury and get the definition right out of your statute. Define an occupational disease claim. So an accidental injury, if I were to define it off the top of my head, it's an injury that occurs as a result of an event, and it occurs immediately or very soon after the event. And then you give the example, for instance, lifting a box and feeling an immediate pain, or falling, being in an accident and suffering an immediate a contusion or broken bone as a result of the accident. An occupational disease is something that occurs from repetitive trauma over time. An example of that would be carpal tunnel syndrome or a shoulder overuse problem. So you would give an example and the definition of the type of event. And then after you've provided examples of each claim under the definition, then, so you have the first part of your policy saying, here are the types of claims that you can have in a workers' comp context. And then the second part of your policy would then discuss, oops, sorry, can't find my little, trying to go back. Nope, I'm going forward. Nope. Huh. I'm very apologize for this. There we go. My back button wasn't showing down there. All right. Sorry about that. So back onto the workers' comp policies and the best practices. Okay. And so you also want to set out reporting obligations in the second part of your policy. So again, in my mind, accidental injuries should be reported as soon as possible, but not later than the statute of limitations for filing of claims within your state. As you can see, for Oregon, the statute of limitations is 90 days. So they should report it immediately, but in no case later than the 90 days. If they report it after the 90 days, then they can't even file a workers' comp claim because they haven't met their statute of limitations. So cite your state law and basically also make sure to indicate that failure to report an injury immediately won't result in disciplinary action, but it's requested to keep the workplace safe for all employees. So that is something that OSHA really wants to see, is that you're not going to discipline somebody for not reporting an accident immediately, because that's what the new rule says. And then for occupational disease claims, you would want to say employees may not know right away that workplace conditions have caused an occupational disease claim, because these occur gradually over time. So set out your state's laws for reporting these claims. In Oregon, it's a year from the date that you knew or should have known that work was a causative factor in your accidental disease claim. So that's my suggestion, and you can work with your own counsel on what they might suggest for how to deal with this part of the new OSHA reg. Okay, and then you also, in your workers' comp policy, you want to include a section on the employer's responsibility. And your responsibility is to get the Form 801 or whatever the number of the form is called in your state and turn it into the carrier. Also, if you have a modified return to work policy, you may want to check your state law and find out if that is required to be in writing. In Oregon, you're required to have that in writing, because if you don't, and then you offer an employee a job, a modified duty job, to get them back to work and off time loss, and they decline the job, maybe they don't want to do that modified duty job because they want to sit home and get time loss. But if they decline the job, then you can cut off their time loss and they won't get time loss. Only in Oregon, anyway, if you've got this written modified return to work language in your policy. So check your state policy and make sure that that's something that you're required to do. Again, check your drug and alcohol policy for any language that states that you'll automatically send an employee's injured on the job in for drug testing. You'll want to decide how you're going to do that. Are you just going to go ahead and risk, as some of my clients are doing, OSHA's ire on that if you get caught with a blanket drug and alcohol policy, or are you going to revise your drug and alcohol policy as, with language similar to the language that I've suggested? Okay. And that's all of the rest of the bullets, and there are things that we've talked about. All right, so we're going to move away from OSHA, and we're going to move to the top potential changes that you might see in state and federal law. And the state section of this, it was kind of, difficult because, of course, every state is different, completely different with respect to state employment laws. Some states are very restrictive, and others aren't. So, oops, I do not know what just happened there. There we go. So You want to be, obviously what I'm going to say here may or may not be happening in your state. I just tried to give you an idea of sort of the kind of changes that are happening in a number of states. So what I'm seeing, the trends that I'm seeing are paid sick leave. So, in most states, you're not required to offer vacation or sick leave. It's completely up to you to do that or not. And that's the way it used to be in my state, Oregon, and also in Washington. Following California, the states on the West Coast here seem to be getting more and more employee friendly. So now in Oregon, we have a paid sick leave law that requires that employers pay a certain for a certain number of hours of sick leave every year. The other law that we're seeing popping up in several states are predictive scheduling laws. And these are laws that basically say that you have to enter sort of into an interactive process conversation with your employees when you're deciding when they're going to be when they're going to be scheduled to work, and allow them to be basically give you, reasons why maybe they can't work at those times that you're scheduling them, or, if they are disabled, or there's some sort of disability involved, why they need certain times as opposed to the times that you've given them. This is a law that's currently a statute or bill, I should say, that's currently pending and is being hotly fought here in my state. And I'll give you a little more information about the bill in my state, because that may be a bill that you're going to see in your state as well. My state got it from California. So paid family medical leave is another thing that you may see. What that tends to be is something that looks like unemployment insurance. It's a state fund. The employee and the employer might have to pay into that fund a certain amount, and then if the employee needs family medical leave, they can then recover from that fund. Again, California has had it for many years, and now Oregon has a bill that's going through our legislature. Stricter privacy laws, and we will talk about that. Okay, so currently on paid sick leave, 11 states have statutes that provide for paid sick leave, and I've listed the states there. So if your state is there, then you already have a statute that provides for paid sick leave. And because it's like 11 states, I think that you can think that there may be more coming up. And of course, if you're in a state that is typically very employer friendly and they just don't enact laws like this, then, that's probably not something that you need to worry about. But if you're in a state that, does enact laws that favor employees and you don't have a paid sick leave, then that may be something you're going to be looking at this year or in the next legislative session or sometime in the future. These statutes, they're different state to state, but for the most part, they allow employees who already have paid sick days to use them to care for certain family members. So that's what these 11 states do. 4 states have statutes that require employers to provide paid sick leave. These 11 states only require, that if they're already have these, it's only for very certain limited circumstances to care for certain family members, whereas these other 4 states, it's much broader. And it would cover the FMLA type illnesses, an employee's own illness, the illness of a family member. And also these laws include something called SAFE paid leave that allows victims of assault or domestic violence to use paid sick leave for their leave. So the following laws allow employees to earn paid sick leave to recover from short-term illness, care for a family member, or to seek routine medical care. And so you've got, not only do you have states doing this, but you have, if a state isn't going to do it, what ends up happening is the city does it or the county does it. So you may get little pockets within a state that are more liberal than others, and so those pockets will then enact these laws. And that tends to be how the state law gets on the books, because you've got the counties or the cities enacting laws and you've got these large employers that may have employees all over the state, but they have to treat employees in these specific counties or cities more favorably than their other employees in the state because they happen to live in a county or city that's enacted one of these laws. And so when that happens, then the state legislature tends to look at it and step in and enact a state law. So that's how the state laws get on the books. But San Francisco, this is all in California, all of these cities, Washington, D.C., you can see Washington in certain areas. Now, Washington has just passed a paid sick leave law for the state, so that's going to be more than just those cities. Minneapolis and St. Paul, New York City, Philadelphia, and then all of these other cities down here, which are in New Jersey. So, okay, so the typical features you're going to see in these laws, they allow employees to accrue time, for example, 1 hour for every 30 hours worked. Some statutes provide for maximum use of time, for example, no more than 40 hours per year. Some statutes have carryover figures that allow employees to carry time over from 1 year to the next. Some statutes allow for employers who have PTO policies that provide substantially similar benefits to be able to use that PTO policy for the sick leave. And most statutes are going to contain anti-retaliation provisions and recover attorney fees. So just like the Federal Family Medical Leave Act, or if your state has a State Family Medical Leave Act, now you have another protected class in your state, and that's people that use that protected sick time. Okay, so moving on to predictive scheduling. I think that a minimum number of states are doing this, but again, where this starts is in counties and cities, so keep that in mind. And I've mentioned a little bit about this, so I'm not going to spend a lot of time on it, but these are laws or ordinances that require employers to provide advance notice of an employee's work schedule. And where this is where this really started was in the big box areas like the Walmarts, where, they would schedule employees and then they changed their scheduling, and employees, didn't have the ability to get daycare in time because their schedule changed, or they got daycare and they paid for it and now they don't need it. So because those schedules were so unpredictable, that has basically led to this predictive scheduling that is kind of going to apply to all employers in some states. So it also creates requirements for all employers relating to ensuring that employees have certain, numbers of hours in their shifts. It creates additional requirements for small and large employers. So, okay. Let's see, that was the same slide, sorry, moving forward. Okay, so again, this started in the cities. San Francisco enacted the first ordinance in 2014. Then it went through other cities in California, in Seattle, in New York. They've all considered predictive scheduling bills last year. As of 2016, bills were pending in all of these states: Oregon, California, Arizona, Minnesota, Illinois, Indiana, Michigan. So you can read all of the states. If your state's there, then, as of 2016 anyway, your state legislature has considered. Some may have enacted, some may not have enacted. This year in Oregon, in 2017, it is something that is currently going through our legislature, and I don't know whether it will be enacted or not. And I'm just using the Oregon bill as an example. If this passed, all employers would need to pay employees at least 4 hours, or the number of hours missed on any day that the employee does not work the employee's scheduled shift in its entirety because of the employer. So the employee sent them home early or canceled their shift. And they have to notify employees 24 hours before the shift not to work, or to work less than that shift. So that's pretty onerous, and the employers in our state are going crazy because the idea of paying 4 hours, if, for some reason you have to cancel a shift, what happens if there's a snow event and you shut work down? What happens if a machine breaks and you have to send your employees home? So employers in Oregon are really very worried about this law because it would really affect them and cost them a ton of money. So employers are also going to need to consider, sorry about that, requests for all of these reasons to work specific hours, work at specific locations, exchange work shifts, telecommute, work part-time, job share, work additional shifts or hours. So large employers in retail, and in Oregon, we have this large employer section. So I'll just leave it at that, large employers with over 25 employees in these three sections, retail, hospitality, or food service, are going to have more requirements because of the bill if it's passed. So I'm not going to, because have 15 minutes left, I don't want to go too much into detail in the Oregon bill, but the Oregon bill was taken from other bills. So what you see in Oregon, if it happens in your state, you're probably going to see something pretty similar. So just for retail, what does that mean? And it's going to be determined from the NAICS code. Okay, so these are other things that are the Oregon bill, taken from the California bill, soon to be maybe a bill in your state, includes engaging in the interactive process, granting requests unless bona fide business reason, providing good faith estimate of the work schedule, providing 14 days advance notice, providing certain breaks between shifts, or to pay, like this is when people have to both close and open a facility. If they don't have very much time, if they're both closing one day and opening the next day, then there's going to be some rules regarding that. And there's additional stuff that I didn't think was necessary to put all of it in because it retains to the Oregon bill. So the paid family leave, we've talked a little bit about that. California, Rhode Island, Washington, New Jersey, New York all have paid family leave on the books. As I've said, Oregon has a bill pending this year. In most states, it's an insurance program, and you contribute a percentage of payroll. The state administers it, and then the employees can use it for various FMLA or a state medical leave type reasons. Okay, so we're going to move into data breach and privacy laws. What's happening there. 47 states currently have data breach and privacy laws that require private or governmental entities to notify individuals of security breaches for information involving personally identifiable information. And we're going to define that in a minute. Typically, the state laws contain the following provisions. It says who has to comply with the law. It defines what personal information is. And usually it's going to be a combination, the name, their birth date, combined with the driver's license or social security number or state ID number. And that information together is like nitroglycerin in terms of data breaches. And you have to be really careful because someone can then steal the person's identity. Most of these state laws are going to say what constitutes a breach, and they are going to give a requirement for notice. When do you have to give notice of that a breach has occurred? Okay, so that's just a little bit on privacy and data breach laws. These are, again, most of the states have them now, and if your state doesn't have one, it may have one soon. And again, we're just really talking about trends here. This next discussion really isn't just a trend. I wanted to put this in because it's fairly new. And if you don't, it's something that people have to really step up and do right now. So this only applies to federal contractors. So if you're not a federal contractor, you don't have to listen for the next couple of slides. But this became effective on January 19, 2017. And it basically says companies who have federal agency contracts that involve the handling of personally identifiable information have to identify employees who handle or access PII and provide annual training. So you have to provide training to these employees when they become hired and then every year on how to protect the PII. And again, it only involves federal contractors who have contracts or contractors that have, and all companies are all subcontractors to that federal contractor, so it flows way down the chain, and it only deals with contractors that have access to a government system of records. So it's a specific, very specific subset of those folks. The new regulations, as I said, are going to require that federal contractors provide role-based training that's specific to the employee's position. So, for example, if the employee is an HR person and they have access to a system of records because of that, you'd want role-based training related to what they do with the records. If they're an IT person, it may be a little different. Some banks have access to a federal system of records, bankers, you might look at that differently. So it has to be role-based depending on what the employee does. And then it has to cover various topics. It has to go over the Privacy Act of 1974, discuss the appropriate way to handle and safeguard PII. It has to talk about the authorized and official use of a system of records. Has to provide restrictions on the use of authorized equipment to collect, use, process, store, maintain, all of these words, to protect anyway the PII. It has to have prohibitions against the unauthorized use of the system of records and procedures in the event of a data breach, which is why I covered data breach before I covered this. Okay, so briefly, we have about 10 minutes left here. I'm going to go through the federal law changes. That's one of them. But these are, this is really predictions on my part. If I had a crystal ball in front of me, what would I think was going to happen with respect to federal law due to the change of administrations that we've had? So I think what we do know is that President Trump wants fewer regulations and wants to undo some of the regulations that we have in place. We think there is going to be an easing up on the federal level on employers on many fronts. So it's going to get better for employers on the federal level in a lot of different areas. What that's going to happen in a lot of states, states that are predicted, want to provide more protection to their employees, is as the federal government eases up, I think you can expect state governments to pick up the slack. Not only state governments, but also counties that are very liberal, so little pockets within states. So some of the things we're going to see are attacks on arbitration under the NLRB or other laws. And so there have been recent efforts under the Obama administration to attack the ability to arbitrate claims that have come from the National Labor Relations Board and against arbitration agreements, and also from the Department of Labor's ban on pre-dispute arbitration provisions under the Fair Pay and Safe Workplaces Act. So we can expect those things are probably going to be overturned under a new Trump administration. There are going to probably be changes to the EEO form. I think that, we may see that there are going to be efforts to dump what the Obama administration did with respect to more requirements on EEO reporting. So that's another thing that we may see. Again, these are predictions, so take it for what that's worth. I think we can also expect to see changes in the other following areas. Class action waivers. There have been a lot of fights against whether you can have a class action waiver. I think you'll see a trend that class action waivers are going to be more accepted. Joint employers, of course, that the joint employment, almost every, there's been a lot of litigation, and especially in the National Labor Relations Board area, that basically says employers are joint employers. So they're making it more easy to be a joint employer. I think you're going to see that ease up, and there isn't going to be as much of that, hopefully. Inclusion of temporary workers in bargaining units. So this is specifically a union issue. Quickie elections is a union issue. You're going to see changes on that. whereas the quickie elections were allowed. I think we're going to see a back off of that. The expansion of protected concerted activities under the National Labor Relations Act, that would apply to anyone, most employers. You don't have to be unionized to have Section 7 of the National Labor Relations Act apply to you. That's the section that says that employees have the right to concerted activities in the workplace, meaning 2 or more employees have the right to talk and complain about the terms and conditions of their employment, and they have the right to bring complaints to the management. So I think you're going to see an easing up of that, especially where the NLRB has been attacking social media policies and employee handbooks. You're going to see a definition of the definition of appropriate bargaining units is going to probably change. And the status of college and university adjunct faculty, graduate students, and student athletes may change. The efforts that have been made in the Obama administration with respect to their status, especially as employees under the, and subject to the Fair Labor Standards Act, that will probably ease up. Oops, let's see. And we think, given that Trump is, on this campaign for immigration and wanting to restrict immigration, that, for sure, you've already started to see discussion about the H-1B visas. So there's going to be definitely a change on H-1B. And then we're also going to see the legislature encourage more employers to use E-Verify, which is currently voluntary. So you might see even mandatory requirements to use it. For government enforcement, I think we're going to see a return to more traditional conservative theories of discrimination that were previously recognized by federal courts. Having said that, we did just have the Seventh Circuit say that sexual orientation was something that was protected under Title VII. So, just federal courts, as we all know from the immigration situation that occurred when Trump issued the ban on immigration, federal courts are separate. There's a separation of powers in our country, and federal courts aren't necessarily going to act in the way that President Trump or his administration might like to see the law go. So, however, as President Trump is allowed to appoint more and more federal judges, I think over time we're going to see that a more conservative approach and the federal courts and in the Supreme Court with Justice Gorsuch now on the bench is going to be different from the approach that was taken by more judges that have a more liberal philosophy. We might also see the EEOC relax its enforcement activity and its positions on the Americans with Disabilities Act, Title VII, and the Pregnancy Disability Act. So I think definitely you're going to see less enforcement, and they're not going to. You're not going to see as much just action by them, and we're also going to be looking for what the administration is going to do. And we already know that, there isn't any, it's only one circuit, the Seventh, that's found that sexual orientation is protected, but other circuits may follow. And potentially that may be an issue for the Supreme Court one of these days, but what's the administration going to do? Obama really did everything he could to, say that LGBT issues were covered by Title VII. So I think we're going to see a backing off of that by the Trump administration to the extent that he can do anything. Trade secret protection, we've got this in 2016, a recently enacted Federal Defend Trade Secrets Act, which gives companies a better and easier access to federal courts to argue that trade secrets have been misappropriated. And I think that under a new administration, we're going to see additional protectionist policies to bring additional enforcement efforts to protect trade secrets, especially those flowing into other countries like China. Other possible changes: increasing cybersecurity management. That new federal law that I talked to you about with respect to federal government contractors, there have already been a bunch of changes to what's called the Federal Acquisition Regulation that deals with stricter cybersecurity management. And especially after what occurred in the election, you're going to see the federal government really making more and more laws to try and get companies, to the extent they can control the companies, and they can if they're federal contractors, to have much stricter cybersecurity management, so that hacks don't happen as easily. We may see a comeback of opinion letters with respect to the DOL, and a decrease in the government regulations around healthcare, energy, and the environment. We also might see limitations against post-employment restrictions. So, in other words, we might see, I think the Trump administration is not going to like non-competition agreements because they're going to see them as a restraint on trade. So they're not going to want to see companies have as much of an ability, to the extent they can, to get a non-competition agreement and say that employees who leave after they're terminated or if they quit can't go to work for another company that makes the same product or works in the same area. So we may see limitations on that. Right now, the limitations that we're seeing are strictly on the state level. But, we could see something on the federal level. We could see an increase in the scrutiny of the DOL's fiduciary rule and a repeal of the Dodd-Frank Act and heavier reliance on the Sarbanes-Oxley Act. So those are all possibilities. So we're to the end. Just 1 minute over here. If any of you have questions and you want to put them in the chat box, I'd be happy to try to address them for you to the extent I can. I'm not going to be able to answer specific things about changes in your states because unless I put them up on the board there in my slides, I may not know about them all. But happy to answer any questions on the OSHA rule or anything else that you have. And if we have no questions, which I don't see anything in the chat box, I thank you all for sitting through this hour with me. I love doing these webinars for hrsimple. And if you wanted to re-listen to any of this, you will get the recording soon. So with that, thanks for attending.
Yeah, thank you, Jean. I just wanted to say something at the very end. If you are an Oregonian, I think is the term for it.
Yep.
Okay, good. You might be interested in obtaining a copy of Jean's book, The Oregon Human Resources Manual. That can be found on hrsimple.com or by calling hrsimple at 866-439-2227. So Jean's book was great. Was a great book in 2016, and I believe we are going to publish it again in, let me look, the end of May. So if you wanted to go ahead and get your hands on that, just go to hrsimple.com. If you're not from Oregon,